from things like that. That's important to remember, because we're seeing that a lot now, where juvies are saying, I want my attorney right away. And they're not understanding that you still do have to identify yourself, especially if you're being detained for reasonable suspicion or probable cause.
Correct. Excellent point. Thank you for bringing that up. All righty. Officer Washington.
Okay, our boys want offenses and more, 500.
Offenses and more for 500. I love when that competition jumps in there.
You are on the street pointing a BB gun at your friend when police officers see you. What could happen if you don't drop it right away? A, the police could take your BB gun and not give it back. B, the police could shoot you in the leg if they think you are going to shoot your friend. C, the police could shoot you in the chest if they think you are going to shoot your friend. And D, nothing, it's only a BB gun. Our team says C.
Okay, Officer Dave, I'm going to ask you to jump in here again.
C is correct. And the one that said the officer could shoot you in the leg. So in law enforcement throughout our country, or it's not in the training to shoot a suspect in the leg, especially when you guys seen a lot of these BB guns, they look just like a real firearm.
Right.
So the officer, his perception when he first gets there right away is going to be that you're pointing a firearm at your friend. And their training goes to shoot center mass. So that's why C is correct. And the best thing to do is and I don't want to, I know it's pretty obvious, but it needs to be said, is to just drop it immediately and do what the officer says, and then explain, hey, it's a BB gun, instead of trying to, hey, no, it's only a BB gun, and try to turn around or yell. Just drop it immediately and do what he says. Once it's safe, hey, sir, it's just a BB gun.
Excellent. Thank you. And let me just add a couple more things on there. This is really important to understand, and even for adults, is that police officers, as Officer Dave said, are trained in a certain manner. We are trained to exercise deadly force against that which we believe is imminent danger to my safety or the safety of someone else. Imminent means right now, that I believe from my training and experience that your life is in danger right now, and I am authorized to use deadly force. Police officers are trained in the use of deadly force, which is shooting center mass, obviously in the chest and head area. Police officers are not trained to shoot in the kneecap. They're not trained to shoot in the elbow, the ankle, the Achilles tendon. That's not what we are trained to do. We are trained to shoot center mass. So as Officer Dave said, when confronted with the police, immediately drop it, follow all of the orders, because if police believe that their life or the life of their partner or the life of innocent civilians are in imminent danger, they are authorized to use deadly force. However, and I pause here and say, however, we have witnessed on the news over the last couple of years shootings that have taken place where the officer's judgment is suspect. We understand that has happened. We understand that mistakes have happened. We understand that criminal behavior has happened on the part of police officers. And this is why it is so important for our kids to really understand what deadly force is and when police officers are authorized to use deadly force, because this is not a game. And this game is obviously built to explain what police can and cannot do, but it's also built to explain what we as private citizens should and should not do when we're interacting with police officers. So great question and great conversation. Thank you, David.
I just have a quick question.
Yes, Dr. Young.
Okay. So, what I often see, and, I was a principal at one of my kind of middle schools too, and people tend to minimize the BB gun, but I have seen those BB guns can do a lot of harm. It can hurt. I know one kid got an eye put out with a BB gun. I don't know if it has the power to kill somebody. I don't know because I've never used it, but they can be dangerous. I mean, from what I've seen. So what's the thought about the BB gun? And it gets kind of played down. Oh, it's just a BB gun. I mean, right. How do we deal with that?
Well, there's a couple lanes of conversation there. You have to remember that a BB gun or a pellet gun, if you shoot it at a police officer and you put his eye out, you've now availed yourself to his firearm on his side. So this is where we remind kids and adults that every call a police officer goes on, there is at least one firearm present. It just happens to be on his or her hip, but there's a firearm present. If you turn and fire a BB gun at me and you disable me in some way that I'm not able to defend myself, you get my firearm, you kill me with my own gun. That was obviously a justified use of deadly force within most departmental policies. I'm going to say all departmental policies. There are also have been occasions, and maybe Officer Dave has experienced this, I know I have, where the super soaker squirt guns that used to be out, that people were taking them apart and putting real guns inside of those squirt guns. So they were walking around with these squirt guns. Police thought they were just squirt guns, and we found them to be actual firearms. So it's a bad place to be for police officers. And I feel bad for officers who are on the job today because it's a split-second judgment call. Do you believe that your life or the life of someone else was in imminent danger? And then can you articulate that? BB gun, squirt gun, real gun, or whatever, because we always have to remember on every call, there is a firearm present. And if you disable me in some way, then you have access to my firearm. So it's a big challenge. When it goes to court, it can become a very different conversation. Some jurisdictions, if it's not a firearm, cannot charge under their local statutes. It has to be a firearm. That's why it's sent to be tested. Guns that won't fire bullets are not considered firearms, and that charge may be reduced. BB guns are in the same category. But some jurisdictions, and I think Las Vegas, it doesn't matter if it's a BB gun, squirt gun, whatever the case may be. If you presented it as a firearm and the victim believed it was a firearm, you are going to be charged with a firearm or could be charged with a firearm. So that application varies across the country.
Absolutely correct, Dr. Clark. You can be charged in Las Vegas with pointing a BB gun at somebody with assault with a deadly weapon. And the reason why is because if that person believes it was a firearm and they are in fear for their life, they don't know the difference. The same with armed robbery also here. If you go in, you rob a convenience store and it's a BB gun at the end of it, you're still going to be charged with robbery with a deadly weapon.
Yeah, and he's absolutely right. And that's why I wanted to say that some jurisdictions won't charge because, again, looking at the challenge of the systems, a lot of people are, reduced charges are being released, and highly unlikely in some jurisdictions that you would go to jail for a BB gun. There may be some other charges, but likely in some jurisdictions it could be drastically reduced or dismissed altogether. And again, that's a systems conversation. But it's important to understand, as I began with, what is the letter of the law and what is the spirit of the law. Okay? Excellent. Uncle Gary. Uncle Gary? Are you on mute?
Oh, sorry. Okay. Excuse me. Offenses and more for 400.
Offenses and more for 400.
Right.
Everybody's going for the big ones today.
Oh yeah, I'm trying to keep up with Anthony and Dr. Young, so they. Okay.
Dr. Clark, I think did you go with offenses and more, or did you go with just offenses?
offenses and more.
Yeah, you said offensives and more, Uncle Gary, but I
Right.
didn't know if it was connect. I thought it clicked on to just only offenses. I'm just trying to keep it fair here.
Yeah.
Right.
And I apologize. I probably misheard him. I'm not able to back up the question, so Uncle
Okay.
Gary, you'll have to
All
run
right.
the question.
Okay. I'm just
Okay.
checking. I'm watching.
She's honest today. She's honest today.
Yeah, she definitely. Yep. Yeah. Maybe I can get an extra 100 points for that. For your mistake. I'm trying to keep up with Ashley and Dr. Young. Okay, so John is mad at his girlfriend for cheating on him. He tells her he is going to kill her. He also posts that on Facebook. What could happen to John? Nothing. He has a right to free speech. Nothing. He didn't mean it. He was just talking crazy. C, he could be arrested for making criminal threats. D, he could be arrested for threats against his girlfriend, but only if other people, only people saw the threads on Facebook. Okay, so I am discussing it with my imaginary teammates. Okay, all right, I like that. Okay, good. Okay, all right. So in the end, they all agreed unanimously that the answer would be C. He could be arrested for making criminal threats.
Okay. Officer Dave, I'm going to ask you to come in and offer some commentary on this one as well, because this has really become a big issue today.
Yes, definitely. So this is what I work with a lot. So because I work in our counterterrorism section, and it is, as Dr. Clark said, we're getting it a lot. And so you can definitely be charged. You can be charged with threats if you go on social media. We won't pick a certain one, just any one of them, and you make threats to your school, place of business, any kind of organization like that. You can be charged with terroristic threats. It's just social media has become, I get it, it's the nowadays hangout, and it's just, you got to be so careful what you say on there, because law enforcement is trying to do their job. So when they get these reports, they're going to do be most diligent and try to find out what is going on. And a lot of times we place the charges to make an example so that we don't see it over and over again, especially when it comes to school violence. And we see a lot of juveniles getting on and threatening their schools and threatening teachers and principals and staff. That is, can't be tolerated, because as we know in this country, it's actually happened. So we have to take it very seriously. And a lot of times we're not looking to ruin people's lives. We'll get these kids help, things like that. But it's absolutely against the law to go on any of the social media platforms and threaten a person or an organization or an entity.
Excellent. Any questions about that? This is a really big question, because this is happening a lot today. I'll give you a real life example. If you remember when Cruz did the school shooting at Stoneman Douglas in Florida, he was actually on social media previously to that, making threats that he was going to be a school shooter. And those threats and those leads were just not followed through well enough to prevent that shooting. And he showed up at a school that he was kicked out of and killed several students and teachers. So as Officer Davis said, law enforcement is taking this very seriously. They have units now and officers and joint terrorism task forces that are constantly looking at social media for these kinds of events. I can guarantee you that the shooting that took place a couple days ago in Atlanta, Georgia, at the massage parlors, that they are absolutely looking at that young man's social media to see what he was saying on social media and if something was missed. So this is very serious today.
Great point. And if you see somebody doing that on social media, please report it, because you could be stopping people from being hurt or killed.
Excellent.
A lot of the reports we get, suspicious activity reports, are reported by just regular citizens seeing it and reporting it to us.
Okay, and if you don't mind, I'd like to highlight something here. Okay, so he tells her he's going to kill her. So without posting that anywhere, so it's more of a person to person. It seems to me that there's some categories here. If he says that to her and they are alone, then I don't know. I know that could be used for evidence or at least to make him a suspect if something did happen to her. But I don't know whether or not that is a crime. I would say no, but you can answer that. And also, if he tells her he's going to kill her and it's a crowd of people, that gives me the impression or gives the appearance used like Facebook. He's not posting to Facebook, but he's telling several people hears that when he says it. So the question becomes, if there's many people around and he says that and the public hears it, is it a crime at that point? Officer Dave, I guess.
Yeah, Officer Dave, go right ahead.
Okay, so just to clarify, Uncle Gary, your question is, if he's just threatening a person to person compared to putting it on social media, is it still a crime?
Okay, not social media, but just a crowd of people around. Not actually social media, just a few people that's around to hear it.
So if I have a problem with you, person to person, and I threaten you, yes, I can be charged there. And then if it's a crowd of people, it's kind of pushing it unless I'm, say I stand up in a crowd and I say, I'm going to come blow up the school tomorrow. Now that's a different story. Yes. Did I answer your question?
Okay, so you're saying that if I say I'm going to kill you in a crowd, I'm talking to a specific person, but the crowd hears it, could I be arrested and charged?
Yes, because I'm threatening that specific person, but they're different charges. So if I just threaten you anywhere, even if it's with one person present, yes, I can be arrested for that. And if I yell out in a crowd that I'm going to do something, especially mass casualty, something like that, I can be charged for that too. But the crowd does not have to be present for me to charge a person for threatening another person. You can actually even be charged on text messages through investigation, and if I can prove that I text you a threat, I still can be charged for that.
Got it. Okay, thank you.
And Uncle Gary, the one thing I want to add to that a lot of people don't really understand, because again, kids say a lot of things to kids all the time. But the important part of the evidence is what did the victim believe, right? So if Officer Dave said something threatening to me and I took that threat seriously and I believe that he was going to do something to me, that's really all that matters. Mm-hmm. I can go to the police, they can file a report, and they would talk to Officer Dave and see, did he have the capability to carry out what he was going to do? But the emphasis really is placed on the victim. Does the victim believe that he's going to kill me, right? So if she believes that he is going to kill her and follows through with filing a report, talking to police and detectives and that whole thing, it could then still be a substantiated charge, even if he comes back and says, "Oh, I was just playing," or whatever. No, she believed that the threat was real.
Got it. Okay, thank you.
Yes, sir. All righty. Great conversation.
Could I just ask one real quick question?
Yes, Doctor.
Dr. Clark, I guess it was maybe 20, 30 years or so ago, and I can't remember the exact terminology, but it had to do with the post office threats, or there was some law or federal guidelines that said they used to kind of play off somebody's threat, and they used the post office syndrome or their post office threat, that somebody would be upset about their job and make a threat at the post office, and then they kept looking at the research, and people were coming back and carrying out those threats.
Correct.
And I don't know if that was federal or if it went to state, but I remember hearing a lot about that, about those threats going through the post office, and either federal laws kind of made some connection to those threats, and maybe they were passed down through the states, but I can't remember the exact scenario that was, how that took place.
Yeah, I'm not familiar with the scenario you're talking about. Maybe Officer Dave is, but I can share with you that making any kinds of threats, verbally, text message, social media, walking in the lunchroom and saying, I'm gonna blow this place up, those things are taken 1,000% more serious than they were just a few years ago. And it's because of all of the incidents that we've had, clearly. So a lot
Yeah,
of
and
go ahead, Officer Dave, please.
oh no, go ahead.
Nope.
And Dr. Young, I don't know if I'm answering your question correctly, but to a federal entity, it does go into a different category because it becomes federal charges. I don't know if that's maybe what you're thinking about.
And yeah, and I there was probably 2 or 3 incidents quite a few years ago where a gentleman was fired and came back and made threats to the supervisor and to some of the other colleagues that he was going to come back and kill some people, and they blew it off. Okay, they did. They kind of go, oh, he's just kind of spouting up, but he came back and he killed about 3 of them plus the supervisor. So, and they then there was something like federal laws or some kind of laws that took place that said any threat now becomes that. It's a threat. We take it seriously, and it's an offense. It's a criminal, not a criminal. Well, I guess I'm not sure if you call it criminal act, but certainly merits a response that either takes that person in custody or charges. So
yes, and Las Vegas, I work in our counterterrorism section, and any threats in Las Vegas, I know we take very serious. Every single one of them, even if at the end it ends up being nothing, we still take it very serious. And I'm thinking you might think, I do remember something with the post office, their policy was changed about any threats. It goes straight to criminal, law enforcement, and there's more reports internally done on it and all that.
Excellent. This is an excellent conversation because this is great information that our kids need. So thank you for all of that. Okay, Mr. Jones.
Okay, we'll have juvenile justice for 400, please.
Juvenile justice for 400.
True, false. Juvenile justice is at an all-time high across the country. Dr. Young, I think that's probably true.
I would support that. It is true.
Okay, so we'll go with A, true.
Herb.
Okay.
Oh no.
Yeah, remember when I said that in comparison to the 90s, it is not at an all-time high.
Yep.
No.
So juvenile crime is at an all-time high across the country. That's actually false, because if you go back and I don't know the numbers in Vegas, but I can tell you in Los Angeles in the early part of the 90s, they were having over 1,200 and 1,300 murders a year. And now they're around 350.
Oh.
So it's not at an all-time high across the country. Certain offenses are higher than they used to be, clearly. But overall, juvenile crime is not at an all-time high across the country. Officer Dave?
I agree. And I think a lot has to do with the change in policing that we have seen. And not knocking old policing, not knocking any of it, but we've learned, and we're reaching out to the youth. There's a lot of more youth programs. There's a lot more education. And then, of course, as Dr. Clark said, the drug and the gang problem has a lot of resources going into it, and it's working. I mean, of course, there's a lot further we need to go, but it's working.
Could I make a comment just real
Yes, ma'am.
quick?
Yes, ma'am.
You know, they talk about the school to prison pipeline, starting with students. They use those reading scores. At least they talk about the reading scores and talk about how students are kind of being targeted in the earlier grades based on their academic level of proficiency. And I think they use reading scores, as I recall, between second and third grade to determine the kind of what we call capacity in juvenile facilities. They call them beds of some sort. So, you know, that's still kind of a big thing kind of going on a little bit about the number of students that have been targeted based on their academic levels going forward, and how they're building the capacity for prisons based on that data 15 years from now, that then house students for whose students now become adults for prison containment. So I don't know, is there anything to that? Because we get a lot of that, quite frankly, the school to prison pipeline.
Officer Dave, would you like to respond?
So there is a lot of I was actually talking to a gentleman the other day, and he was telling me some statistics, and I looked them up because I was just curious. And there's a lot that goes into that, but there is high statistics in a lot of the youth in certain demographic areas, and especially who have parents who are incarcerated. The odds are just against them for going to be incarcerated himself or going to prison. But I don't know with the what Dr. Young was talking about. Maybe you do, Dr. Clark.
Yeah, the research is very interesting, because what is getting lost in a little bit of it, not all of it, but certainly some of it, are all of the diversion programs that are out there now for juveniles, and the mediation programs that are out there. They are still considered a part of the system, but they're not a part of the system that I used to be a part of. I became a police officer in 1986, so I can remember, when I say back in the day, I can remember back in the day when there weren't really very many options. If kids were getting in trouble, they just got arrested, and they were just part of the system. And we didn't really have optional resources to bring them to. So like juvenile courts are working very differently today. Diversion programs, mediation programs, alternative sentencing programs. Those things are much more robust today, but they are skewing the numbers because they are still a part of the system. And that's why, as we all know, it's really important to dig down into that research. I know that there's a lot of other sociological things that are impacting the juvenile criminal justice system, like education and housing and healthcare and mental health care, stable families. The foster care system is its own tragedy in and of itself. So there's a lot of areas that are really skewing these numbers. And it's really challenging to have a very substantive conversation about, are we actually creating a school to prison pipeline where essentially it looks that way, but today there are so many other alternative and diversionary programs that weren't present 20 years ago.
Thank you.
We should probably get 100 points then instead of getting the 400.
Hey, Dr. Clark, you know who would, Officer Washington would probably, are you there, Officer Washington?
Officer Washington, are you there?
They had to, it's after 4.
Oh,
And
okay.
I saw the note, the boys had to go to dinner.
Okay. All righty. Well,
But we're on till 4:30 because we said we would be on the extra 30 minutes for those who need it. So we did schedule till 4:30 today. But for juvenile, since they had a jump start on training, they are okay with being released because they've had
Okay.
a couple weeks ahead.
So let me go ahead and be Officer Washington for a second. I'll take police youth interactions for 400, and everybody can participate in this question.
Do we get points?
Yeah.
Dr. Young.
Yeah. Great question here. You are a passenger in a car that is pulled over for speeding. May the officer ask you to get out of the car? No, because the car was pulled over for a traffic violation. No, police may only ask the driver to get out of the car. Yes, for officer's safety. Of course, I know the answer, but I'll let everybody else chime in.
Well, it's a traffic violation. It's a traffic violation. So unless the officer can create a scenario that would show that the occupants inside the vehicle pose an immediate threat to him or her, I would think that he could probably leave the other occupants inside the vehicle unless you know they would show some sort of a threat. Anybody else?
Um,
Yeah, go ahead. Who's that? Dr. Young? Or?
no, go ahead, Uncle.
Oh, okay. Yeah, this is kind of, from my perspective, this is somewhat of an ambiguous question. First of all, the question only asks, may the officer ask you to get out the car? You know, I mean, well, the officer could ask you anything he want to ask you, really. So, you know, I guess the question is whether or not you have to get out the car if the officer asked you. So when I review the question again, I think that was Anthony said that you are a passenger in the car that is pulled over for speeding, which is a traffic violation. I don't know how different states may vary. I really believe that federal law would require probable cause to have you get out your car, because you are infringing. When the officer asked me to get out the car, I'm infringing on where he's infringing on my right to be secure and reason to be secure in my person. So I shouldn't have to get out the car. So of the three answers that they give, you know, because it seems like, yes, the officer is doing it for his safety, he'd have to probably show that. But I believe that, yes, if we chose that he could do that for his own safety, that he could do it up under any circumstances and then simply claim it was for his safety. So if I was answering that, I would actually say no. I would actually say A.
Okay. Anyone else?
I know the answer, but I'll wait till I know Dr. Young wanted to say something.
Well, the only reason I was going to go with C, if the officer is coming up to a car and he suspects that there may be somebody hiding in the back seat, and he's not quite sure if he comes up to the door. He saw a head, and then he gets up to the car and he doesn't see, and he sees two, but he thought he saw three. And I think he hesitates. He says, I need everybody to get out of the car for his own safety. That's the only reason I would say I would lean towards C. Because officers I've seen officers go up on the side of the car and they thought there were two people, and there were two people in the back seat, and, you know, people got ambushed or whatever, you know, I don't know. That's just my thought.
Okay. No, that's all good. That's all good. Anyone else have any other comments?
I concur. I don't know the terminology. I think it's like imminent danger. If they suspect that imminent danger, I may not be using the right one. I'm watching too much crime TV lately. I think so. But not unless they, you know, suspect there would be something, you know, that they would walk upon that would cause them harm. But other than that, you know, I'm thinking it's a traffic violation. You know, they're speeding.
Right. Okay. Officer Dave?
So the Supreme Court has ruled that officer conducting an investigation. So for a reasonable suspicion or probable cause, they pull you over, speeding, tail light, whatever the offense is, that they can ask you to exit the vehicle for their safety at any time during that traffic stop. So, and I'll tell you from an officer's perspective too. You, as the driver, might not realize it might be a dark night. It could be a glares on the window. It could be anything where he or she doesn't feel comfortable, and it's easier for them to talk to everybody outside the vehicle. It could even be a traffic hazard that he doesn't feel comfortable with your vehicle being there, and his vehicle, where he might want to ask you to step out and go over to the sidewalk and talk where it's a little more safe. So just to let you know that on the officer's perspective of it.
I would say that Officer Dave. Okay, I was thinking in terms of, for example, say for instance, you're in your own home and the police knocks on your door, and there's people in your house. Can you ask everybody in the house to step outside because of his, for safety reasons? So even though I think I disagree with you a little bit on that one, I may be wrong, and you're probably correct because you're probably the expert. But the logic, without any more information in the question, they was investigating, or the car had done something, or there's possibility they were a suspect in a robbery or something that occurred. Without something more, police just stopping whatever car, having everybody get out every time you stop a car. That seems like it might cause some confusion with the law. And I think the law probably anticipates that would be a problem. So I will still stick to from the information that's given, I'm simply a passenger in the car, and the car was pulled over, that the officer he has the right to ask me to get out of the car. Without any more information, it was just that, I would say no. So again, I say no.
Yeah, that's why I'm so glad this question is, it's a great question, especially for the youth.
It's an excellent question, and this has all been excellent conversation. And this is why we play the game, so that we can talk through all of these things and really understand what the police authority is. I'll give the answer in a second, but just let me add this commentary. Police officers have a wide range of authority. As I said earlier, they also have a wide range of discretion. If for any reason, and the standard is reasonable suspicion, which is less than probable cause, that the officer safety may be in jeopardy, he would obviously be able to ask people to get out of the car. He already has probable cause that a crime has occurred because he stopped the car for a crime. So he already has a crime that has occurred. But when it comes to his safety, if he has reasonable suspicion to believe that his safety may be in jeopardy, he would have the authority and the discretion to ask everyone to get out of the car. And you will remember, again, back in the day when you would see, and I'll go back to Los Angeles, I don't know if Las Vegas was doing this, but they would get everyone out of the car. Everyone would be handcuffed, kneeling or sitting on the curb. And that's how they were doing car stops back in the day. I don't know if Las Vegas was doing that. It's not very popular across the country now to go that over the top. But still, the officer has a wide range of discretion if they have reasonable suspicion to be concerned for their safety. And if there's 2 or 3 people in the car, I can tell you as a police officer or former police officer, everybody's getting out of the car because there's only me. And I want to make sure that, I'm going to be safe, probably call for backup. You don't know how the driver's reacting. You don't know how everyone else in the car is reacting. And that's why it's so important for all of us to really understand what the procedures are and how this police officer is interacting with the vehicle and the occupants of the vehicle. Now, I will say on the other side of the coin, are some egregious things have happened that police officers have done? Clearly, that has been the case. We've seen it on video, and I'm not here to refute that. But I am here to help us understand and explain what the authority is and what his procedure or her procedure will be based on their authority and based on the reasonableness of their suspicion And they ultimately are going to have to articulate that in a report if it gets to that part, or if you complain. So as a passenger, you go down to the police department and you file a complaint. Officer Clark got me out of the car. I don't think he should have. I want to file a complaint. You have the right to go and engage in that process as well. If there's any merit to it, they'll call the officer in and they'll either take an official or unofficial statement from them. But as long as the officer is acting within their authority with reasonableness, and that's the court's standard, with reasonableness, then the officer is going to be okay. So obviously the answer is yes for officer safety.
Okay.
All righty. Uncle Gary, and I'm sorry, friends, we have 10 minutes left.
Okay. So thank you, Dr. Young, for missing yours. This will give me an opportunity to take the lead. So offenses and more for 400.
Offenses and
Ooh,
more.
I take a big lead.
Go Uncle Gary.
Oh,
All
boy.
right.
Oh boy.
Oh yeah. Oh, wait a minute. I might have spoke too soon here. Wait a minute.
Yeah.
Okay, true or false? Driving under the influence of marijuana carries the same penalties as driving under the influence of alcohol. Oh yeah. Okay. So again, my team they're back there saying we got to get this one. So I said, okay. I'm talking to the team. The team said, all right, they finally agree. It's only one of my team members that did not agree, but the others did. That marijuana, alcohol, what difference does it make if they're up under the influence of any controlled substance or controlled substance? I don't even know if marijuana is a controlled substance, but I'm gonna say yes. It carries the same penalties as being under the influence of alcohol. So my answer would be true on that.
And that's correct. As I'm sure Officer Dave can tell you as well. The law used to be driving while intoxicated. I know I'm dating myself, DWI. It has since changed to driving under the influence, and that includes alcohol, illegal drugs, and prescription medication as well. So if you've taken too many Xanax and you're impaired to operate a motor vehicle, you can still be charged with DUI, driving under the influence.
Okay, good. Thank you.
All right. Mr. Jones.
Mr. Jones has had to leave, but
Okay,
we do have
Dr.
Nicole Thompson. She's kind of our backup. So
Okay,
Nicole,
Ms.
you're on.
All right, let's go for offenses and more. Let's go for 300.
Offenses and more for 300.
So which is true of the robbery law in California if you are charged as an adult? Is it A, if you possess a gun during a robbery, you get an extra 10 years in state prison? Is it B, if you possess a BB gun during a robbery, you get an extra 10 years in state prison? Is it C, if you fire a gun during a robbery, you get an extra 20 years in state prison? D, all of the above, or E, A, and C? So I think I need to consult my team on this one. And I am from California, so, but I'm not of these laws. Let me see. Is it just you and I, Dr. Young?
Yeah, it is. I'm kind of thinking of D because if you have a gun or a BB gun or fire a gun, anything like that, I think that carries extra penalty. So I'm saying even that BB gun, sometimes you don't even know. We just talked about, we don't even know if it's real or not because it looks real. So yeah. I don't differentiate the BB gun from a gun. So I would say D.
B.
I
Yeah,
would,
I'm gonna go with you because California has been rough and tough and all that stuff. And thus you've been, we're seeing a whole lot of flux of individuals from California fleeing to other states such as Las Vegas, but they are stiffening up on their policies and their penalties. So I'm gonna go with Dr. Young. We're gonna go with all of the above.
D.
D.
D. So that is
no.
obviously incorrect. And here's why. Remember when I said that in California, if it's not a firearm, that they are most likely going to dismiss that charge, and it's because of the enhancement that comes along with that. So
With
you
the
could
BB
imagine
gun.
how many people in California were using BB guns that are sitting in prison in an overcrowded prison system and county jail
okay.
system. And I know this is an unfair question because I obviously know this from having worked over there. All jurisdictions don't have firearm enhancements. Officer Dave, does Las Vegas have firearm enhancements?
I'm not an enhancement, but on some of the gang stuff they do,
Okay.
but not on a regular charge. You'll be charged with a firearm charge, but not an
Okay.
enhancement.
And some jurisdictions were doing this because of all the gang violence. They had gang enhancements, they had firearm enhancements, but clearly now with the overcrowding of the prison systems and other things like that, they're looking at this, and in California they won't. Some jurisdictions they will. So you may be somewhere in the Midwest. It doesn't even matter if it's a piece of a gun that's taped together. If the victim believed it was a gun, you're going to get the 10 years if that's what it is. So this was a little bit of an unfair question.
Yeah, so what was the right answer?
A and C.
Thank you.
Okay, because that BB gun is not considered to be kind of a real gun, so to speak.
Yes. So in California, what they'll do is the statute says it has to be a firearm. And then there's a classification for a firearm. In other words, it must fire a bullet.
Okay.
If it doesn't fire a bullet, they have the option to dismiss it. Obviously, it depends on the circumstances of the crime and and all that other stuff, and how the victim felt at the time. And those of us that are a little bit more seasoned will remember back in the day when people used to put their hand in a brown paper bag and rob places, or put their hand in their coat pocket and rob places. That's going way back, but the victim believed it was a gun, so they would get charged with the gun. Some jurisdictions are not doing that simply because of system overcrowding.
Well, I'm from Ohio, and Ohio, if BB gun, play gun, wooden gun, anything from
Yeah.
Ohio, they if the perception is it even has the appearance of a gun, they they throw everything in that.
Yeah, and Dr. Young, I'm from Youngstown, Ohio. I was a police officer in Youngstown, and if you broke a branch off a tree and put it in your coat pocket, it was a gun. So
yeah, and see, I'm from Dayton, and they called us Little Chicago over there. So
yeah, so I know exactly what you're talking about. Okay, Uncle Gary, let's do. I'm sorry. Let's do one more question because we're at our time, and I want to be respectful of everyone's time. Or maybe, you know what, maybe we'll do no more questions. Let's just kind of do a closeout here. Are there any questions about the game or what we're doing? Maybe that's the best use of our time.
I just have a quick question.
Sure.
Okay. I really like this format. I think it makes it gamey, but very informative. It allows for discussion, and it makes it, has a little competitive edge to it. So it can't, because I'm in education, and I was just thinking about this for a lot of things. Is this format adaptable to, let's say, I just had a big early childhood learning institute, and we got a lot of little factual things that go on with practically all of our different components in education. Is this adaptable to doing something like that? And can somebody like me be able to put in different questions and
Oh, yes.
bring that around to, this is your topic, juvenile justice jeopardy, but I'm talking about other educational topics like this.
I believe so. I don't want to speak for Lisa Thoreau, who's the executive director for Strategies for Youth. Now, this game comes in what we're playing is called the street version, right?
Mhm.
So that means it's street related things. They also have a school-based version. They have a sexual exploitation version. There's several different versions. So that would be a conversation to have with Ms. Thoreau.
Sure.
And I'm sure it can be very adaptable to what you want it to
Well, I love it. I love the format. I know we're over time, so I'm with you. I always try to respect people's time as well.
Yeah, I do as well. Friends, go ahead. I'm sorry, Ms. Thompson, go ahead.
Is this format for next week? Is it 3 o'clock or 4 o'clock?
I believe our next training session is at 3 o'clock.
Okay, because I thought I was on at 4, and I will have to make arrangements because I do, I'm working on site right now.
Right.
We're getting ready for our hybrid model, which is going to start on Monday, but I do want to be respectful of your time, and I apologize for being late today because I thought I was on time.
It's quite all right. Thank you.
Yeah, I left work early to get here at 4, and you guys started at 3. So
Yeah.
No
I do want to be attentive to the time, and I'm looking forward to having my students participate and
It'll be a lot of
the